Do you know what to do whenever a tenant violates their obligations? Hi, everybody. I'm attorney Tim Baldwin, and I specialize in landlord tenant law in the state of Florida. So what are the steps you need to take? The first thing is to go to the lease or the statute 83.52 in the state of Florida and make sure that you know what provision or what statute the tenant has violated. Without that, you can't go forward. The next thing is to gather sufficient evidence that can prove the tenant violated the lease. That may include going to the property, inspecting, taking pictures, talking to witnesses, but you have to have enough evidence to be able to prove in case the tenant contests what you're saying. The next thing is to prepare a specific notice that requires the tenant to cure the violation within the notice period. And in Florida, that's a 7-day notice to cure, or if it's non-curable, a 7-day notice to terminate. Now, if your lease has more than 7 days required for a cure or termination, then you have to follow your lease agreement. The next thing to do is you want to make sure you don't waive your right to enforce the violation. Now, in Florida, 83.56 provides that if you accept rent with knowledge of the violation, that you may waive that violation. In other words, you can't file the eviction. However, there are some exceptions, and one of them is if the violation is continuing in nature. The other is if you accept only partial rent from the tenant. Read the article below, learn more about it. Thanks, y'all, for watching.